Hello, everyone. Today we are analyzing the GNCTD ordinance, which was brought by the central government to give itself the ultimate power over controlling the civil servants who are working in the government of National Capital Territory of Delhi. This ordinance was brought within a week after the Supreme Court's Constitution bench delivered a judgment upholding the power of Delhi government over control of services, except in three areas, which are public order, police, and land. So except in these three specified areas, the Delhi government will have the power to control the transfer, postings, and other matters related to the civil servants who are serving the government, the Delhi government. This was the Supreme Court's Constitution bench judgment. So now this ordinance has been brought, which has the effect of nullifying the Supreme Court's judgment. So after the ordinance has been promulgated, intense debates are going on regarding the validity of the ordinance. There are several legal debates and also political debates regarding this issue. So in this video, I'll be advancing an argument that the Delhi ordinance, this GNCTD amendment ordinance, that is unconstitutional for nullifying the Supreme Court's judgment. Of course, there are several nuances and counter arguments in this issue. So I'll try to meet the counter arguments as well. So before getting into the debate, we need to make some concepts clear. Can the legislature, by making a law, overrule a judgment delivered by a court? This is the primary issue which we have to understand. And the answer is not a straightforward yes. So there is a little bit nuance here. The legislature can indeed overrule a judgment or can neutralize the effect of a judgment in certain circumstances. For example, a law can be made to take away the legal basis of a judgment. The law can also be made to cure the defects in a statute which led to a particular judgment. For example, I will try to explain with an example. For example, a court has held that a decision taken by an authority that is unsustainable because that authority had no power to do so. He had no power to take that decision. So this was the court's decision. Later, the legislature can neutralize this judgment by amending the law to confer the statutory power on that particular authority. And this can be given retrospective effect to validate the decision or the action which was taken by the authority, which the court interfered due to lack of legislative power. So that legislative defect can be cured by amending the law and by taking away the basis of the judgment. So in this example, the basis of the judgment was that the authority had no power. So when the parliament or the legislative assembly gives the requisite power to that authority, that basis of the judgment is gone. So now the judgment cannot stand on the basis of the present law. So this is one way of legislative overruling of judgments. And this is permitted. There are several Supreme Court precedents which have discussed these aspects and which have held that legislative overruling is permissible by taking away the basis of the judgment, by taking away the legal basis of a judgment, or it can be done to cure the defects which are in a law. For example, in the recent Jallikattu matter, so there was this argument that the state amendments made by the Tamil Nadu Assembly as well as the Karnataka and Maharashtra assemblies, they are unconstitutional because they are going against the 2014 judgment of the Supreme Court, which banned Jallikattu practices. But recently, the Supreme Court held that these laws are not, they can't be invalidated for violating a Supreme Court's judgment because these laws are basically curing the defects which were pointed out in the earlier judgment. For example, in the earlier judgment, it was pointed out that these practices cannot be permitted because animals are being subjected to cruelty. So in the second round of litigation, the court held that these laws are basically ensuring that the animal activities like Jallikattu, etc., can be held without causing pain and suffering to animals. So this was the finding made by the court. So to cure the defects which are pointed out by the court, you can make law, and to that effect, the previous judgment can be nullified. So these are the basic principles. But if a law is made by merely declaring that a judgment will have no effect, and the judgment will be overruled, then such a law will be unconstitutional. For example, in 2014, there was this case between state of Kerala and state of Tamil Nadu. So in that case, the issue was regarding the validity of a law made by the Kerala Assembly, which declared that the water level of the Mullaperiyar Dam cannot be raised beyond a certain point. So this law was against the Supreme Court's judgment. So in that case between Kerala and Tamil Nadu, a constitution bench of the Supreme Court held that this law is unconstitutional because it has been made to overrule a Supreme Court's judgment. So if such a law is made, that will be a violation of the doctrine of separation of powers, and such a law can be struck down for violating Article 14. This was the principle laid down by the court. And this principle was applied recently also in 2021 in the Madras Bar Association case, where the Tribunal Reforms Ordinance brought by the central government, that was invalidated by the court for violating a previous Supreme Court judgment. So in that judgment also, it was reiterated that if a law is made only to overrule a judgment, then that cannot be sustained. That is unsustainable, that is unconstitutional, because doctrine of separation of powers, that's a very basic structure of the Constitution, and if that is violated, the law cannot be sustained. This was the principle. So these are the background principles which we have to keep in mind before getting into this issue. So when it comes to the Delhi Ordinance, we need to analyze what the ordinance is actually doing. So one more clarification I need to make. So this is an ordinance. So even when an ordinance is made, the union government is exercising legislative powers. So the principles relating to legislative overruling and all those principles will apply to an ordinance as well, although it has been issued by the executive and not the parliament, but the same principles will apply. So the Delhi Ordinance, so there is an interesting provision in that GNCTD amendment ordinance, that is section 3 of that ordinance. So that section 3 seeks to amend the Parent Act. The Parent Act is the GNCTD Act, and to insert a new section there, section 3A. What the section says that, what section 3A essentially says is that, notwithstanding whatever is said in any judgment or in any court ruling, the Delhi government will not have powers over entry 41 subject to of list 2 of the Constitution. And entry 41 is the entry which is relating to services. So basically section 3A says that Delhi government will have no powers over services. And this is directly contradicting the Supreme Court's judgment, which says that Delhi government will have power over services. So section 3A has the effect of overriding the Supreme Court's judgment. So to that extent, we are now clear that this ordinance has the effect of overriding the Supreme Court judgment. Now, whether this is a permissible act or not, to understand that or to analyze that, we need to see if this ordinance is taking away the basis of the Supreme Court's judgment. If the ordinance is taking away the basis of the Supreme Court's judgment and is overruling it, then that is a permissible activity. That is the precedent, as I explained earlier. So what is the basis of the Supreme Court's judgment? The Supreme Court's ruling is primarily based on Article 239AA of the Constitution, which is the constitutional provision which deals with the powers of the Delhi government and also the Delhi Assembly. So 239AA sub-article 3. So this is the crucial article which operates as the basis of the Supreme Court's judgment. What this article basically says is that the Delhi government or the Delhi Assembly, they will have Delhi Assembly will have legislative powers on all subjects in the list 2, except 3 entries, which are entry 1, 2, and 18, which are basically dealing with public order, police, and land. So except these 3 entries, Delhi Assembly will have powers. And if the Delhi Assembly is having powers, as a consequence, the Delhi government will also have powers. This was the Supreme Court's, this is what the article says. So the Supreme Court noted that, okay, so this article has specifically exempted 3 entries. Only 3 entries have been exempted. Services is not exempted. Entry 41 is not exempted. So since entry 41 is not exempted, so going by Article 239 AA, the Delhi Assembly will have powers. This is the long and short of the Supreme Court judgment, that it's primarily based on the text of Article 239 AA, subarticle 3, subarticle A. This is basically the basis of the Supreme Court's judgment. So now we need to see if the ordinance has taken away the basis of the judgment. Now remember, Article 239 AA, that's a constitutional provision. You cannot amend a constitutional provision through an ordinance. It's very obvious. So the basis of the judgment is still there, even after the ordinance. The ordinance has not made any change or any impact on the constitutional provision. And it cannot also, because it's an ordinance. So to amend a constitutional provision, you need to bring a constitutional amendment as per Article 368. And there's a separate requirement for constitutional amendment. You need special majority, 2/3 majority of the Parliament, and also majority support of the legislative assemblies of the state also with respect to certain articles. So you need to have there is a special procedure. There is a separate procedure for constitutional amendment. And an ordinance cannot amend a constitutional article. It's very clear. So the basis of the judgment is still there. The basis of the judgment, which is Article 239 AA, subarticle 3, that is still there intact even after the ordinance. So that is one thing. Now, in response to this argument, there could be a counter argument, which is based on Article 239 AA, subarticle 7. So this article says that the Parliament has the powers to make any law to give effect to or supplement any provisions in Article 239 AA. And the next article, the subarticle B, further says that a law made by the Parliament under subarticle 7 that will not be regarded as that will not be regarded as a constitutional amendment. So relying on this provision, there could be an argument that to make any changes to Article 239 AA, you need not make any constitutional amendment. A constitutional amendment may not be necessary. So that is a possible legal argument. But here, one needs to look at the keywords in Article 239 AA, subarticle 7. So as per this provision, the Parliament can make law for giving effect to or to supplement the other provisions of Article 239 AA. So can this ordinance be regarded as a provision, as a law, which is giving effect to or supplementing the other provisions of Article 239 AA? In my opinion, it is not. Because this ordinance is basically diluting Article 239 AA. Because as per the article, the Delhi government has powers over all subjects in list 2, except 3 specified entries. That is public order, police, and land. Now, this ordinance is including one more exempted category, that is services. So essentially, this article is diluting or degrading or downgrading the main article, that is Article 239 AA. So such a provision cannot be regarded as a law which is giving effect to or supplementing Article 239 AA. It is in fact downgrading Article 239 AA. So this law, this ordinance that cannot be regarded as a law which is made under Article 239 AA, subarticle 7. So this is my view. Now, there could be another counter argument. That is based on certain observations made by the Supreme Court in the judgment. So when the ordinance was published and a lot of debates were happening in social media and elsewhere, several supporters of the ordinance were extensively quoting from one paragraph of the Supreme Court's judgment. That is paragraph 94 of the judgment. Sorry, paragraph 95 of the judgment. So in that paragraph, basically the court observed that so long as there is no power, there is no law made by the Parliament over other subjects in list 2. The powers of the union government will be limited only to 3 entries, that is public order, police, and land. So there is one observation made by the Supreme Court in that paragraph. I'll read that paragraph for benefit of all the viewers. I'm quoting from the Supreme Court's judgment. However, if Parliament enacts a law granting executive power on any subject which is within the domain of NCTD, the executive power of the LG shall be modified to that extent as provided in that law. So, relying on this observation, it is argued that, okay, the court itself has given liberty to Parliament to make a law on the subject of services. And if such a law is made, then the Delhi's LG will have power over services. That is, if Parliament is making a law on services, as a corollary, the union government will have powers. So the argument is that, okay, the Supreme Court itself has recognized the power of the Parliament to make such a law. So that this ordinance can be brought in to give power to the Delhi LG over the services. This is the argument. Now, we need to see these observations in the context of the judgment itself. These observations basically are a restatement of what the Supreme Court held in the 2018 case. There was an earlier round of litigation between Delhi government and the union government regarding the powers of the elected government and the LG. And a constitution bench delivered a judgment in 2018, interpreting the constitutional provisions and outlining the sphere of powers between both these executive wings. So in that judgment, the court held that the Parliament also has powers in all matters in list 2 in relation to Delhi Assembly, which means the Parliament can also make laws on subjects which are mentioned in the state list in relation to the Delhi National Capital Territory of Delhi. This was the interpretation given by the Supreme Court in 2018. So so there is an additional power for the Parliament. For example, the Parliament cannot make laws on state subjects with respect to other state assemblies. That is a clear principle. But in the case of Delhi, there is an exception that the Parliament can make powers over state subjects also in relation to Delhi government. So this was held in 2018 itself. And if Parliament is making such a law, then consequently, the union government will also have power over that subject on which the Parliament has made a law. Okay, so this was a principle which was laid down in 2018 Constitutional Bench judgment. So in paragraph 95 of the present judgment, the Supreme Court is basically restating those principles. So basically summarizing those principles. So the Parliament has power over, the Parliament can make a law on the subject of services. Such a law can be made. Parliament always had that power. So even before this judgment, even after 2018, Supreme Court expressly recognized the power of Parliament. So the Parliament could have brought this law, this very same law, the Parliament could have brought this law before this judgment was delivered. That is my view. So once the Supreme Court has declared that, as per the existing provisions, the Delhi government is the repository of power with respect to services, except the 3 specified categories. After that judgment is delivered, can the Parliament make this law, or can this ordinance be brought simply to overrule that judgment? That is the issue here. I'll just elaborate more. It is not the existence of the power of the Parliament which is in dispute here. The Parliament has power over services. That is a given. That flows from the Supreme Court's judgment way back in 2018 itself. This very law could have been made by the Parliament earlier. No doubt about that. So if the Parliament can make a law, consequently the union government can promulgate this ordinance also. That is also clear. But can this power be exercised to nullify a judgment, to override a judgment? That is the issue here. can this power be exercised to override the judgment without taking away the basis of that judgment? That is the issue here. Nothing else. The existence of the power is not the issue. The exercise of power, that is the issue. Okay. So here, as I explained earlier, this ordinance is not taking away the basis of the judgment. The basis of the judgment is still there. What the ordinance is doing is to simply say that this judgment will have no effect. And that is impermissible as per the settled law, as per the law settled by various precedents. So this clearly goes against the doctrine of separation of powers. Here the ordinance has been brought only to overrule the judgment and to neutralize its effect without affecting its legal basis. That is the key issue here. The legal basis of the judgment is still there. That is not disturbed, but the ordinance has been brought to overrule the judgment. That is the issue here. So going by the principles in the latest Madras Bar Association case and also the previous precedents, this ordinance violates that principle of doctrine of separation of powers, and that is unconstitutional. Now, there is one more angle to approach this issue. The Supreme Court's judgment is not simply based on the text of Article 239AA. The Supreme Court also invokes larger constitutional principles relating to democracy and federalism in the judgment. The court says that before that the court notes that, or takes note of the fact that the Constitution itself has provided that the Delhi government will have a legislative assembly and also an elected government, and will have all powers of a government except in 3 specified areas over which the union government has power. So this is the constitutional provision itself. So when the Constitution has provided an elected government and also a legislative assembly to the Delhi, to the National Capital Territory of Delhi, those provisions will have to be given full effect. This is what the Supreme Court says. So here the Supreme Court invokes the principles of democracy and federalism. The court says that the ultimate administration, the ultimate control of administration, that should be resting with the elected arm of the government. If the elected arm of the government, if the elected government has no power to control the civil servants, then it's not, that is a meaningless government. This is what the court says, not in so many words, I mean, not so directly, but this is the impact of the observations of the Supreme Court's judgment. So if there is no, what is the point in having an elected government if the government has no control over the services? Because the government has been elected by the people. So the government has to represent the will of the people and has to make policies and decisions. And these policies and decisions of the government are to be executed by these civil servants. So the civil servants are basically executing the policy decisions of the government which has been elected. And if these civil servants are not, if they are protected or if they are insulated from the control of the elected government, then the civil servants won't be accountable. They won't be feeling accountable to the government. So this will be essentially derailing the government, and the elected government itself become meaningless. This is what the Supreme Court says. I can read some certain few observations from the Supreme Court's judgment. If the officers stop reporting to ministers or do not abide by the directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of the officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. This is what the Supreme Court says. The court further says, if a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. So this is what the Supreme Court says. So the court reaches the conclusion not just based on the text of the Article 239AA, but also on the principles of democracy and federalism. The court says that if the union government is taking over the powers which are given to the states, then that is undermining the spirit of federalism. That is what the court says. So in the light of, so this ordinance will not square with the observations made by the court regarding democracy and federalism. The court reached the court, while reaching the judgment, the court wanted to avert the danger of the civil servants who are in Delhi being insulated from the Delhi government and being unaccountable to the Delhi government, because the court wanted to further the interests of democracy and federalism. So if you see the ordinance in the light of these observations, so it's very clear that this ordinance cannot be reconciled with the Supreme Court's judgment. So this ordinance is basically perpetuating the very same danger which the Supreme Court wanted to avert. So in effect, the ordinance is nothing but a colorable piece of legislation, which is violating the Supreme Court's judgment, both in its letter and spirit, and is therefore unconstitutional for breaching the doctrine of separation of powers. So thank you so much for watching this video. If you like this video, please click the like button. I have also written an article on this subject, which I'll share in the description as well as in the comment box. So the specifics of the articles and also the judgments are mentioned in the article. So interested readers can read the article also for getting the specifics and particulars. So please subscribe to LiveLaw's page for getting more contents like this. Thank you so much.